Hey everyone, this is Mark Treichel with an emergency episode of With Flying Colors. President Trump has been sued over the firings at NCUA, being sued by Todd Harper, being sued by Tanya Otsuka, both former NCUA board members and who were let go earlier this month. I'm going to walk through a little bit of their legal filing, a little bit of what my take on it is. Again, I'm not an attorney. I'm not a lawyer. I've spent a lot of time with attorneys and lawyers at NCUA. So I understand some of what makes them tick. I did a little bit of research on the case, did a little bit more research, and that's what you're going to hear from me today. All right, so we're going to break this down into three categories: the legal and constitutional framework of the lawsuits. Then we're going to dive into NCUA's specific structure and functions and how it relates to the lawsuit. And then we're going to dive into some of the litigation strategy and broader implications of this lawsuit. This is a slide from one of my recent PowerPoints and one of my recent podcasts. By the way, I've presented this to several leagues across the country, credit union leagues. And if you're with a league and interested in hearing any of this or having any of this presented to your members, feel free to reach out at the contact information at the end of this PowerPoint slide and at the end of this podcast and the end of this YouTube video. All right, so this kind of walks through what has happened at NCUA. And I've got two screens going here, so you might see my eyes darting over. But in February of 2020, the NCUA board agenda mentioned that Todd Harper was going, or that a board member was going to be named vice chair. It's my understanding. And again, on the left, I have timeline, truth, rumor, and intuition. I've heard some of this is truth, some of it is rumor, and some of it's based on all my time at NCUA. I did hear that Hauptman was asked to remove that item from the agenda. They did that. That was followed by Harper and Otsuka taking on, that was followed by Hauptman changing the overdraft and NSF reporting that had been put in place by Harper for billion-dollar plus credit unions. That was followed by Harper and Otsuka issuing statements vehemently against that, saying, what's wrong with transparency? Transparency is a hard word to argue about. Then there were closed meetings, a couple closed meetings to get NCUA's downsizing plan approved. By the way, they're going to be talking about that at the May board meeting, according to the agenda that came out and a statement that came out from Hauptman. All right, so they had the downsizing going. It first didn't get approved, then it got approved by a 2-to-1 vote, I'm told. And then NCUA announces they're going to have a briefing on this. And then DOJ arrives at NCUA. And then allegedly DOJ is unhappy with the lack of following presidential orders, if you will, particularly as it relates to having staff back on site. I'm hearing that some things have been decided and they're going to be forcing the union staff back on site also. So April 15th, Harper and Otsuka were fired via email. That came from a statement. The email reference came from a statement that Otsuka made, and that is reiterated here in the lawsuit. NCUA canceled their board meeting. Then NCUA, after a couple of days, comes out with a statement to staff saying that a quorum is one. The Federal Credit Union Act requires a quorum for the NCUA board to act. Well, they're saying if there's only one, then a quorum is one. And then NCUA on April 23rd, a couple of days ago, announces they are reopening succession planning and the simplification of insurance rule, which would require board action, meaning that Hauptman plans to act as a board member of one, theoretically. All right, so that's a little bit of background on how we got here. And then reporting this on April 29th, this will go up on April 29th. Yesterday, Otsuka and Harper filed a lawsuit against President Trump, Scott Bessent, Larry Fazio, and others in the chain of command. Although I would argue Fazio's not in the chain of command, but he probably had to take some actions at NCUA, like taking away their access to their computers, taking away access to their email, taking away access to the building that a staff member would have to do, which is probably why his name is in the lawsuit. All right, next slide is the NCUA specific structure and Next slide, the legal and constitutional framework. So we're going to walk through the constitutional showdown beginning. We're going to what at pleasure means versus independence in the 1978 restructuring. We're going to talk through the Humphreys executor precedent protecting independent agencies. unitary executive versus congressional design, the narrowing path of agency independence, Robert Swan versus Bill Clinton, that's also NCUA, and the 50 years of respect for for fixed terms that have been in place at the agency. So first up, case background and context. So this newly filed lawsuit, Harper versus Trump, challenges President Trump's unprecedented removal of two National Credit Union Administration board members earlier this month. This marks the first time in NCUA's 50-year history that a president has removed board members during their fixed terms, and that's key, creating a constitutional showdown over executive power. These removals allegedly came with no explanation or cause, delivered through identical one-sentence emails from the White House Presidential Personnel Office. So, second bullet, the 1978 restructuring and the implied removal protection. Congress significantly restructured the NCUA in 1978, replacing a single administrator who explicitly served at the pleasure of the president with a multi-member board. This deliberate removal of at-pleasure language, combined with fixed terms and other structural elements, forms the basis of the plaintiff's argument that board members have implied removal protection. The complaint specifically cites Senator McIntyre's statement that the amendment was intended to transfer management from a single administrator serving at the presidential pleasure to a board with fixed terms. If you've listened to my other podcasts, I often talk about how an NCUA rule is a 3-act play. You have the proposed rule and the preamble to that. You have the final rule, which is proposed and voted on, and you have the preamble, and you have the actual language of the rule that gets approved. And what they're, in my opinion, saying here is there were statements by Senator McIntyre which shows the intent of why they made that change. And I'll tell my clients sometimes that, for example, you want to understand why the commercial loan rule reads like it does, read the preamble. They'll say what their intent is. So they're, I think, cleverly showing that the intent was to take away presidential power by creating this board, as opposed to saying that they can just be flat out terminated. So the Humphreys executor precedent and independent agency precedent. So in 1935, Humphreys executor case established that Congress can limit presidential removal powers for officials at independent agencies that perform quasi-legislative and quasi-judicial functions. This precedent has protected independent regulatory agencies for nearly a century, though recent Supreme Court cases have begun to narrow its application. The plaintiffs are relying heavily on this precedent, arguing that the NCUA structure and functions place it squarely within the Humphreys framework. So that's what Harper and Otsuka are arguing. So the unitary executive theory versus congressional authority. So this case represents a clash between the unitary executive theory, which holds that the president must have authority to remove officials who exercise executive power. And by the way, that's what the press secretary said. He's the president. He can fire whoever he wants. Previous podcast, I had her exact quote on that. And Congress's authority to structure independent agencies. So let me repeat that. This case represents a clash between the unitary executive theory, and this theory holds that the president must have authority to remove officials who exercise executive power, and Congress's authority to structure independent agencies. Recent Supreme Court cases have trended towards expanding presidential authority, making this case particularly significant. This theoretical conflict has profound implications for administrative governance and the separation of powers in modern American government. So I think that's why they're suing, right? They're saying, hey, we don't think you can do this. We think you can. And it's going to take a probable long journey to resolve all this, which creates other issues, which we will get to. So recent Supreme Court precedents that I've referred to. I'm going to take a sip of my spring water. Although I may need something a little stronger if we have more of these emergency podcasts. So the recent Supreme Court precedent, cases like Seala Law versus CFPB in 2020 and Collins versus Yellen, Janet Yellen, that is, have narrowed Humphrey's executor, suggesting greater presidential removal authority over agency heads who exercise significant executive power. The NCUA case could test the boundaries of these recent precedents in the context of a multi-member financial regulatory board. Of course, that multiple member financial regulatory board is the NCUA board, which typically has 3 board members, typically 2 of the party in power, but that got all mucked up a couple rounds ago. So the situation was you had 2 Ds and 1 R, with an R in the White House, which is probably what triggered some of this, some of the reasons for why they were fired, despite the fact that they had a one-sentence, apparently had a one-sentence firing that didn't really go into any of this. So this NCUA case could test the boundaries of these recent precedents in the context of a multi-member financial regulatory board. The current Supreme Court has shown a willingness to revisit longstanding precedents regarding administrative agencies and executive power. So this Supreme Court has an appetite to take a look at this. They seem to whittle away at the independence of the agency and create more power for the president. So we could be heading for a showdown on this topic at some juncture. So the role of Robert Swan versus Clinton as precedent. So I was at NCUA when Robert Swan got fired by Bill Clinton. I was in the Division of Special Actions at the time, I believe. So the D.C. Circuit's decision in Swan versus Clinton examined NCUA board member removal authority, but ultimately it only assumed removal protection without definitely ruling on it. This creates an interesting precedential situation where the most directly relevant case avoided a final determination on the core issues, leaving significant room for interpretation. The plaintiff cites Swan as supporting their position, while the government, Trump, would likely emphasize its non-binding nature. So they assumed that there were removal protections for Swan. They didn't address it, and then they went on to explain why it was okay for Swan to get fired. I don't want to get into too much detail here, but Harper and Otsuka are saying this helps their case. I would say the fact that it only assumed that they had a case, that Swan had a case, means it doesn't help them as much as they think or hope that it will. And there's probably other stronger items that we'll walk through here or have already walked through that are actually a better defense or a better offense, I guess, for the plaintiffs. So the role of historical non-removal precedent, the role of historical non-removal precedent. The complaint emphasizes that during the board's nearly 50 years of existence, so that's the NCUA board's been around for 50 years, the president has never removed a member whose terms has not yet expired. This administrative precedent could play an important role in the court's analysis, as historical practice often informs interpretation of constitutional boundaries between branches. The unprecedented nature of these removals highlights the case's exceptional significance. So it's interesting they say that history means something. To me, they have the authority and never having used it doesn't mean that they couldn't use it. And I'll make a credit union based comparison. So NCUA says that they can remove officials. The Federal Credit Union says they can. Their policies and procedures establish ways on which they should do that behind the scenes. They've never used that. They'll only remove the entire board. Why? Why just remove one when you can remove all easier? So they've never used that rule, but they claim that they can use it at any point in time. So if I was the Trump administration, I'd be saying, yeah, so what? They've never done it in 50 years. We never had a situation like this where it needed to happen. I think, again, I don't think that's necessarily, in my mind, a very powerful argument. All right, so next slide. Moving to the next slide, the NCUA specific structure and functions. So let's talk about the plaintiffs, Harper and Otsuka. Todd Harper and Tanya Otsuka, the removed NCUA board members at hand, are suing in both personal and official capacities to be reinstated. Harper, previously appointed by Trump and later designated as chair by Biden, had been leading initiatives on financial stability and consumer protection. Otsuka, a more recent appointee, had been focusing on underserved communities' access to financial services, and this is according to their write-up. Both were removed despite having years remaining on their statutory terms, Harper until 2027 and Otsuka until 2029. Now, I'm going to digress here a little bit. So Todd Harper actually had 2 terms, and the Biden administration changed the definition of what a term was. Essentially, they said, if you didn't have 6 full years, you get 2 terms, which has never been how it was interpreted. Oh, by the way, we're up above. They're arguing that this has never happened in 50 years. Well, what had never happened in 50 years was somebody succeeding themselves. Harper succeeding himself and getting another 6-year term. We've had board members come and go and come back. We've never had them run for longer than 6 years. And to me, that's not what the act allows, but no one has challenged that. And at the time that it happened, I remember trade associations and discussions with credit unions saying, hey, if somebody pursues that, you could argue that anything that Todd Harper voted on wasn't a legal vote by the board. And we'll get into that a little bit because I think that has ramifications for discussions as it relates to Houghton and him potentially taking action as a sole board member, claiming that they have that power, claiming that one is a quorum. Whether that's right or wrong, who knows? All right. So the NCUA structure and role in financial regulation. The argument is that NCUA is a core financial regulator. They have a seat at the table at FSOC. It might be at the kids' table, but they do have a seat. All right. So the NCUA structure and role in financial regulation. The NCUA stands alongside the FDIC and Federal Reserve as a core financial regulator, overseeing credit unions that serve 142 million Americans and safeguard over $2 trillion in assets. Its 3-member board, with fixed, staggered terms and bipartisan requirement, was designed by Congress to insulate credit unions' oversight from political pressure. This independence is particularly crucial during financial instability, as demonstrated during the 2023 liquidity crisis mentioned in the complaint. I'm guessing that was the best argument they could come up with, because credit unions didn't really have a liquidity crisis when compared to what happened at Silicon Valley Bank, Signature Bank, which were liquidated over a weekend. And oh, by the way, in my opinion, they bailed people out beyond the $250,000 insurance limit. But again, that's a story for another day. I have podcasts out there on that topic and why I think that was a boondoggle and that it was unprecedented assistance. But that's the argument. I've been around lawyers a lot. They said, you need to explain how you are crucial. And that happened when both of them were there. So they make the argument that I think Otsuka was there in 2023. As I'm getting texts about this as I chat. All right, so we talked about NCUA's structure and role in financial regulation, which they're saying this is something they have to claim as part of the case. So executive functions versus regulatory independence. A central question in the case is whether the NCUA performs substantially executive functions, which favors presidential control, or primarily quasi-legislative and quasi-judicial functions, which would favor independence. The Trump administration would likely characterize the NCUA's supervisory activities as executive in nature, while the plaintiffs position it as similar to the FTC and other independent financial regulators. The complaint specifically highlights the NCUA's rulemaking, consumer protection, and market oversight functions as paralleling the FTC's protected role. And they want to parallel the FTC because of the past Supreme Court case that went forward as it relates to the FTC. So one of the things that I thought about is the NCUSIF ownership structure. So the NCUSIF is owned by insured credit unions themselves rather than the federal government. This creates a unique structure that strengthens the argument for NCUA's independence. This industry-funded model distinguishes it from agencies directly controlling federal funds and suggests a quasi-independent regulatory role. The mutual ownership structure also emphasizes the agency's role as an overseer of a self-insuring system rather than a direct administrator of federal resources. Now, the caveat to that would be if the fund gets wiped out, the taxpayer is liable ultimately. So I think that you can argue both sides of that, but ultimately Treasury would have to, taxpayers would have to fund it if the insurance fund was so insolvent that credit union couldn't fund it themselves by recapitalizing it. So it would be catastrophic, but it's theoretically possible. Now, the central liquidity facility would be an argument in support of the Trump side. So the central liquidity facility and executive authority, the NCUA's central liquidity facility can borrow from the federal financing bank, creating a direct connection to Treasury and federal resources. This relationship could strengthen the argument that the NCUA exercises some executive functions that require presidential oversight, particularly during financial crisis. The administration could argue this borrowing authority involves economic policy decisions that should align with the president's overall financial strategy. Now, as I'm thinking this through, if I was helping one side or the other, which I've done in some lawsuits that impacted NCUA, I would be saying, hey, what has NCUA board members, what has Todd Harper said in front of Congress as it relates to the powers of the central liquidity facility and what they can and what they can't do? I would look for language that was utilized in front of Congress, if I was the Trump side, to try and say, hey, here's why the central liquidity side of it makes this something that is creating a direct connection to the Treasury, and that also strengthens the argument that NCUA exercises some executive functions. I think that'd be a pretty strong argument, but I would try and use their own words against them. I would go search those statements by Harper. Not that anybody from the Trump administration is listening to this, but if they were, that would be my suggestion. All right, the quorum crisis and agency paralysis. Do I need to change slides here? I think I do. Let's see, the CLF, the quorum crisis and agency paralysis. Oh, no, here we go. We're operating without a quorum. So the removal of 2 board members has left the NCUA without the statutory quorum required for board actions. While the administration might argue that a single remaining member constitutes a quorum in emergency situations, the plaintiffs contend this would circumvent Congress's multi-member design and bipartisan requirements. If you only have one, you only have one party in there. That would be the argument. This paralysis has real-world implications for the credit union system's regulatory oversight, potentially affecting millions of Americans who rely on credit unions for financial services. So, what's the sound of one hand clapping? That's a line in a Van Morrison song. A deep dive, a deep cut, if you will. But NCUA has come out publicly and said that one board member can act and that is their longstanding position. It's kind of their longstanding position, in my opinion. Their delegations say that the board can act on anything that's essential, a one-member board, but that's a delegation approved by the board. The Federal Credit Union Act says that you need a quorum. So a quorum will be decided perhaps at some day by the Supreme Court as it relates to this. Okay, financial stability and public interest implications. Beyond the constitutional questions, the case raises serious concerns about financial system stability. The complaint emphasizes that independent financial regulators were designed for good reason. A stable financial system depends on independent regulators who act free from political interference. The outcome could affect how financial regulators navigate future crises and potentially impact market confidence in regulatory independence. So, time will tell as it relates to this. All right, going to our second to last slide, last substantive slide, is the litigation strategy and broader implications of all of this. So the legal strategies and multiple claims. The plaintiffs have filed 6 different counts, including statutory violations, Administrative Procedure Act claims, and constitutional separations of power arguments. This multifaceted approach gives the court several potential grounds on which to decide the case without necessarily resolving all constitutional questions. The complaint strategically includes claims for declaratory judgment. The complaint strategically includes claims for declaratory judgment, injunctive relief, mandamus, whatever that is, and equitable remedies to maximize potential avenues for relief. So they're pursuing this on constitutional basis. They're pursuing this on Administrative Procedure Act claims. It's basically a full court press, throw everything against the wall and see what sticks. So I wanted to do a little research on the legal firm that they hired. And my guess is, oh, by the way, I'm thinking somebody's funding this. Some group is funding this for Harper and Otsuka, because the cost of this are going to add up quickly on the plaintiff's side, and the agency and everybody listed will be represented by the U.S. Attorney's Office. And, they can assign an army to that, and there's no cost to these individuals who, by the way, are not being sued in their personal capacity. They're being sued in their official capacity. But U.S. Attorney's Office is an army, and somebody is funding this. And I'm imagining, while it might be partially Otsuka and partially Harper, that somebody with deep pockets who wants this constitutional issue addressed is funding this. So the small but influential legal team, the plaintiffs are represented by Holwell, Schuster, and Goldberg, LLP, which is called a boutique litigation firm specializing in high-stakes constitutional and complex commercial disputes. They were founded by a former federal judge in 2012. This relatively small firm is taking on a case with potentially far-reaching implications for presidential power and regulatory independence. Their specialized expertise in constitutional litigation may be more valuable than the resources of a large firm in this context. So they have a niche. They found the right people they're in the right niche for what's going on here. And they seem to have done some of this before, which is good for Harper and Otsuka. But again, they're going up against an army, against the U.S. Attorney's Office, and they're going up against a Supreme Court that it leans to the right. So it'll be interesting to see what happens here. So I don't know about the timeline. I did a little bit of research, and what I found out is that cases like this typically take 3 to 5 years to reach Supreme Court decision. If it progresses through all levels of appeal, and given the case's constitutional significance involving presidential power and independent agency structure, it might receive expedited consideration at some of the stages. So does that mean trimming 3 to 5 years to 3, or does that mean trimming 3 years to 1, or is that going to be something like the exporting of illegals that gets, get all the way to the Supreme Court quickly? I don't know. It's going to be interesting, but if it's 3 to 5 years, that creates some challenges in many ways as well. So also, the composition of the Supreme Court by the time the case reaches it will be crucial, as the court has been incrementally reshaping administrative law doctrines in recent years. Because they're more on the right, they're making decisions more with presidential power. And so they may want to get this there sooner than later, which might get it quicker than the 3 to 5 years. So who knows? Maybe that means less than a year. Time will tell. Implications for other independent agencies. The outcome could significantly impact the structure and independence of numerous federal agencies beyond the NCUA, including other financial regulators, the FCC, FTC, and independent boards and commissions across the government. A ruling expanding presidential removal powers could fundamentally reshape the administrative state. Agencies with similar multi-member structures and fixed terms without explicit removal protections would be particularly vulnerable. So it would impact other agencies, but beyond that, let's talk about within the walls of NCUA. So what's going on at NCUA right now is they have a restructuring going on, and 20% of staff have left or committed to leave by the end of the year. That's a big number. And these staff that are leaving are core long-term folks that were either eligible to retire or could do early retirement. So they're losing a lot of corporate knowledge. That's going to create some havoc at the agency and already is. It's going to create morale problems and already is. And when the dust settles, what will the new NCUA look like? Who knows? I have stated in previous podcasts that NCUA staff has a lot of talented people at every level. So people will rise up to the challenges and rise up to be promoted. But they also have some inabilities of hiring right now under the Trump administration. So it's going to be a little chaotic at NCUA right now. But let's go back and discuss my first slide from my previous PowerPoint, where I talked about the fact that Hauptman says he can act on regulation. This lawsuit says they can't. Hauptman says that he is going to reopen the comment period on regulations that have been approved by the past board. Let's talk about succession planning. Trump has said we want to get rid of 10 rules for every one that you put in place. Last administration, it was 2 rules for every 10. This time it's 10 for every one. I don't see Hauptman putting regulations in place. I see him looking to get rid of some regulations. I see him trying to show the administration that he is a good soldier. And I think that's why first they came out saying they could take action. Then they said they're going to reopen the comment period, which is tiptoeing into him taking actions as a board member of one. If they end up canceling those regulations, which I'm going to assume that's where they're heading with succession planning, that would create a situation where how does this play out? As I mentioned earlier, if there had been suits saying Harper didn't have the authority to be in for 2 terms instead of 1 term, which I think would be a pretty good argument, could you unravel everything that had come before it? So you could see, in my opinion, if Harper and Otsuka win that, and/or they decide that a quorum is not one and Hauptman cannot act, that there could be some things that were canceled and pulled away that would go back in place. So that's unknown. It's kind of like the unknowns that we have with the tariffs right now, which is making the market shaky, which is making small businesses shaky, which is making other countries saying, hey, when the dust settles, what are the rules going to be? NCUA staff, with all these other morale problems got going on with the downsizing, I could see people say, hey, you know what? Harper and Otsuka had the right to sue, but this could be what pushes, another 1, 2, 3, 4, 5% of staff out the door. So I think that number will go up. They're going to go, you know what? This is beyond the pale for what those career folks might want to deal with. And I think I think these lawsuits, while they may be appropriate and they may win, I think it's kind of like ripping a scab off for the staff. And it's going to burn a lot of energy that's not focused on the safety and soundness of credit unions. So this is a political battle. This is a personal battle. It may be viewed, never underestimate the power of self-deception. People look for facts that support their position. People on both sides of the aisle are going to argue for what they want to. And credit unions and NCUA staff are stuck in the middle of this. And the sooner it can be resolved, the better, so that the healing can begin, so that the new agency, whatever that might be at the end of all this, can come about. And in my presentations to some of the leagues, I did say, hey, we'll have to see if these folks sue, Harper and Otsuka, that is, and now they've decided to do it, and they seem to have a firm that knows what they're doing. I think it's getting funded by somebody, as I mentioned. And the reality is there's going to be a lot of scabs ripped off between now and when this is resolved. I think it's a sad state of affairs that the industry has to deal with this. And you can, whatever side of the aisle on, you can point blame to either side. And the credit unions are stuck in the middle. The staff are stuck in the middle. I'm kind of disappointed from that perspective. And I'm just going to leave it at that. So I hope you enjoyed this emergency podcast with some of my takes, some of what I've done via research, and some of this was verbatim from that filing. As always, I want to thank you for listening, or if you're on YouTube, I want to thank you for watching. This is Mark Treichel signing off with flying colors.